Lynn, can you hear me?
Good afternoon, Commissioner Lyle.
Good afternoon. How are you? How are you, Carrie? Hello, General Counsel.
Hello, Commissioner. How are you today?
Hey, I'm doing fine. How are you?
Very good.
I see a couple of boxes on here for Commission on Ethics. Are those other staff folks?
Yes, that's our webmaster who controls audience in for public input, etc.
Good.
And then we also have staff monitoring for minutes and minute recording and the like.
Got it.
Good afternoon, Commissioner Deskovich. How are you?
I am well. How are you?
Great, thank you. Good to see you.
Where is our packet? Who'd that come from? So I could pull it up on my screen.
It came from me. It's also posted on our website under the meeting and materials. And if you need it, I can shoot you a quick link.
Nope, I just searched for you. Here it is. Nope. That's not it. Okay, got it.
You do have it?
Yes, I do. Thank you.
Okay, I was ready to send it. All right, good.
Hello, Commissioner Deskovich. How are you?
Oh, how are you?
Very good, thanks.
Is this recording yet?
I do not believe it is recording just yet. I'll check with the webmaster.
It is not recording yet, but we are live streaming, so people are in attendance.
Got it. Thank you.
Commissioner Bain, welcome. Good afternoon.
Oh, good afternoon. Y'all are going to have to excuse me without video. I'm on vacation right now with my family.
Sounds wonderful. It's about that time. Commissioner Lucas, good afternoon. We are not recording yet, but we are live streaming, so there are people in the gallery. Good afternoon, Chair Fuste.
Afternoon, can you hear me okay?
We can hear you, and we are not recording yet, but we are streaming live right now with people in the gallery.
Bought a speaker and a new microphone, but for some reason it's not working today. What are we doing? You guys hear me okay? Yeah, finally got it working. Okay, good.
Okay, do you guys see me now? At least show my microphone's working.
Yeah. I can see your nose really in your mouth as well, and the eye looks good.
Yeah, I don't see. Okay, all right. Well, that better? Because I'm not seeing me, which is usually a good thing, but all right, as long as it works for you guys. Okay, sorry about that. All right, thanks.
Things are good. How about over there? Steve, can you hear me?
Yes, Mr. Chair, I can hear you great.
Yeah, sure. Are we waiting for anybody to get going or?
We are expecting all 8 commissioners, so we were just holding on for.
Okay, no, that's fine.
Yeah.
I'm
Right,
reaching
I'm
out
good.
to make sure that no one's having any technical difficulties.
All right, thanks, guys.
We do have some new members who are joining us, so if you'll indulge them and give them a few minutes to join us. This.
Gary,
Yes,
you hear me better now?
I can hear you well.
Yeah, I know. It's an expensive microphone. I got it working. All right. So we're missing two people, but we can go on and they can join us when they come on. Is that possible?
Yes, they should be able to join in when they get there.
Let's
Oh.
just start because
Commissioner Stewart is on. She did join
Good.
us. Welcome, Commissioner Stewart. Good to see you, Senator.
Commissioner, you're muted.
Commissioner Figurs is logging in now as well.
okay, we'll give it a couple minutes then. If they're all logging in.
Good afternoon, Commissioner Figurs.
Hey, good afternoon, everyone.
Gary, you want to get started?
That's your call, Mr. Chair. We do have a quorum, I believe, if you request the roll call.
We're waiting for just Commissioner Bush, correct?
Commissioner Bush was planning to join us. I reached him a short time ago. But he can join us at any time. You can choose to delay and wait for him to join us or continue on.
No, let me just. Hold on one second. Okay. Yeah, we can start. You want to start with the roll call?
Commissioner Bain? Can you hear me?
Yes.
All right, Commissioner Bush? Commissioner Deskovich?
Present.
Commissioner Figurs?
Present.
Commissioner Fuste?
Present.
Commissioner Lyle?
Present.
Commissioner Lucas?
Present.
Commissioner Stewart? We have a quorum present.
Thank you. All right, just like the commission. All right, we'll get started and we'll address it. Just a couple of brief announcements I'd like to make. Pardon my reading this straight from the screen. I haven't had a chance to prepare. First and foremost, I'd like to welcome our new commissioner, former Representative James Bush, when he comes on. And Representative Bush was appointed to the commission by Speaker Rainier, and Commissioner Bush succeeds Commissioner Newton. We also have former Senator Linda Stewart. Good morning. No, wait, good afternoon. God, I feel like I'm back up in Tallahassee. Senator Stewart was appointed by Senate President Pasadomo and succeeds Michelle Ankers on the commission. We look forward to welcoming you on board and for our next meeting in Tallahassee, and we'll go on with business today. Some preliminary announcements I'd like to make before we start. Please mute your microphones unless you are speaking and keep your video on for the duration of the meeting. Please silence your cell phones as notifications can be disruptive to the live feed. Pursuant to section 286.0114 Florida statutes, members of the public have an opportunity to have input on matters before the commission other than in cases in which we act in a quasi-judicial capacity. The public could provide comment via email prior to today's meeting. I'll ask the commission to briefly unmute the mics. If there's any member of the public who would like to be heard on this matter, please identify yourself. Is there anybody?
Mr. Chair, we did not receive anything by email.
Okay, so let's commence. You have been provided, commissioners, you've been provided with the materials for this meeting that include a summary of our general counsel, as well as relevant filings before the court. At this time, I'll recognize our general counsel, Steve Lukowski, to briefly introduce the matter. I don't know, just Steve sounds better. Steve?
Thank you, Mr. Chair. Commissioners, welcome to our special commission meeting to talk about litigation today. I want to welcome Commissioner Stewart to the commission. This is your first meeting. I'll introduce myself. I'm Steve Zilkowski. I'm your Deputy Executive Director and General Counsel. At our last meeting, we started to have a brief discussion about the Form 6 litigation, and it was decided at that meeting that the commissioners would like to invite our attorney from the Office of the Attorney General, Bill Stafford, to the meeting to have get an update from him on what's going on, and then discuss anything that you would want to discuss at this time. So a vote took place to have a special meeting and to meet in the shade if our counsel thought it was appropriate. As you saw from the memo included by Bill Stafford, the memo that was included in your meeting materials, Mr. Stafford has not requested a shade meeting, but we will meet in the public, and it is appropriate to meet in the public on something like this, where the elements of a shade meeting that I laid out at the last meeting aren't met. So the purpose of today's meeting is to get an update on the litigation and for you to discuss all related matters concerning the litigation. However, this is a public meeting. This is not a shade meeting. Plaintiff's counsel is almost definitely watching this, maybe even recording it. We're recording it. It's a public record, this meeting. Please be aware that the things you say, they may be admissible as the case moves forward. Please consider, as you ask Mr. Stafford questions, whether or not these are questions about litigation strategy and whether or not you just be mindful of that as you ask him questions. You're welcome to do that, but be conscious of it as you're doing that. With that, I will return the floor to the chair so that he can introduce Mr. Stafford.
Steve, and real quick before I introduce Bill, I just like to point out exactly on the piggyback of what Steve said, and Bill, this goes to you as well. If there's something that you feel is in that zone, and there's a lot of attorneys on the board here, please express to us. I noticed your memo that says private attorney-client confidentiality. Well, the minute it's subject to this meeting, I would argue that that's gone. So just be careful if you as the attorney representing us feel that the answer may somehow just express that. Listen, I'm afraid that answer may require, and then we'll take it from there, just step by step. And with that, I'll introduce Mr. Bill Stafford. The floor is yours, sir.
Thank you, Commissioner, and it's an honor to come before the commission, and I'm here to discuss the status and update this litigation. Also want to let you know that on the call with me is Assistant Attorney General Sarah Spears, who's my assistant in this case, has been tremendously helpful. What I will do is just start by a brief background on the litigation for, I guess, for some of the new commissioners. The source of this litigation is the Form 6 requirement that was created by the 1976 Sunshine Amendment. And the Sunshine Amendment directly applies to state and county constitutional officials and candidates for those offices. And that has proceeded for nearly 50 years. In 2023, the legislature enacted amendments to the Sunshine Amendment, basically the implementing statute for the Sunshine Amendment, that extended the Form 6 requirements to municipal elected officials, those in a legislative capacity like the mayors and county or city commissioners, and then also to the members of this commission. That was based on the legislature's own initiative, but it's worth it to note that prior to that, in the annual reports of the commission for the past several years, this exact legislation was recommended by the commission. And in 2024, a lawsuit was filed by a large number of municipal elected officials. The basic claim that these officials are making is that the financial disclosure requirement constitutes compelled speech. And in the parlance of the First Amendment law, the First Amendment protects freedom of speech, obviously, but that has been extended to say it protects freedom from speech and freedom from it being compelled to speak. So that's what this case has been brought on, what it is the plaintiffs are seeking to have it analyzed under. So when this case was initially filed, the plaintiffs filed a motion for a preliminary injunction. That motion was fully briefed and heard, and at the end of that hearing, after some additional briefing, the preliminary injunction was issued and joining the commission from enforcing the amendment to the Form 6 requirement, basically to prevent the commission from enforcing the Form 6 requirement for those municipal elected officials. Since then, the case has proceeded, and the status of that case right now is that motions for summary judgment have been filed both by the plaintiffs and by the commission. That's been fully briefed. The motions, responses, and replies have been filed, and those, I believe, are part of the part of the meeting materials. The court has had previously entered an order regarding the scheduling of those of the summary judgment motions, and also indicating that after the motions were fully briefed, that she would set a hearing, and further that would be a final hearing, essentially indicating that what happens at the summary judgment hearing will constitute the final disposition of this matter. So based on the summary judgment motions, the court will either enter a ruling for the plaintiff or for the defendant. In terms of, if there was a question of litigation strategy, I would say that, there is none right now, because the only thing that's left is for the court to conduct her hearing and issue a final ruling, which would basically be a judgment in this case. If that once that judgment is entered, then depending on what that judgment is, the question would be if there is a ruling against the commission, then the question would be, should the commission appeal? And I can almost guarantee you that if there is a ruling against the plaintiffs, that the plaintiffs will appeal. So hopefully that will not occur, that the commission won't have to determine whether or not it will appeal. But if that comes to pass, I can tell you that the Attorney General feels like that an adverse ruling should be appealed. The issues are, the issues would apply beyond this context in terms of what is compelled speech. I'm happy to summarize just briefly the arguments. Again, they're available in the briefing, and I would not, because it's a public meeting, I would not feel comfortable going beyond what is set forth in the briefings. In this case, the plaintiffs argue essentially that the disclosures that elected officials and candidates are required to make to the commission, and then the commission makes public, constitute compelled speech. And in doing so, the cases that they rely on and say that this is analogous to, our position is that they are distinguishable. For example, some of the cases that Supreme Court has ruled is compelled speech is that, I'm sure that most of you have heard about that, the New Hampshire case about the message on the license plate, live free or die. That was determined to be compelled speech because it required a private citizen to display a message essentially to the public that person, that individual may or may not agree with. Additionally, there was a case that required, in California, that required abortion clinics to provide written notice to patients about the availability of other family planning services available elsewhere. There is a case out of North Carolina that dealt with a statute requiring professional fundraisers to disclose to the public that the percentage of donations that are actually transmitted to the sponsoring charity. And finally, there was a case out of, I think, Oregon or Washington that required owners of buildings open to the public that were not up to the current earthquake code to display a notice that this place has not met the current earthquake code and may not be safe in the event of an earthquake. Those are all determined to be First Amendment cases that implicate the First Amendment because it's compelled speech. And the reason that this is important, whether or not this case implicates the First Amendment, is that if a law impacts the First Amendment, it is generally scrutinized on what's called strict scrutiny, and which has proven over time to be pretty much defaulting. If a statute comes under strict scrutiny, way more often than not, it will be determined to not meet that standard and be declared unconstitutional. Our position is that this does not implicate the First Amendment because the cases that are relied on are distinguishable, and because the statute does not require, first of all, does not require, strike that back up. First of all, it's not applicable to members of the public generally. It's applicable only to elected officials and candidates for office. And secondly, it does not require these elected officials and candidates to make their disclosure to the public. They're not the ones making the disclosure. They're providing the information to the commission, and the commission is making that information available. It's our position that these are important distinctions that would indicate that this case does not involve the First Amendment, and if it doesn't, then it comes under what's called the Plant case. And that was a case that was filed the year following the enactment of the Sunshine Amendment. And that was brought by sitting senators challenging essentially the Form 6 requirements. And the court made the Fifth Circuit, which is now our federal appellate court, ruled that those requirements implicate privacy rights, and under an analysis of the important interests fostered by the Sunshine Amendment, that this certainly satisfies scrutiny as it applies to the privacy interests. That is what I have right now, and like I said, we're waiting on an order from the court setting a final hearing down in Fort Lauderdale or Miami. And I'm happy to answer any questions the commission may have.
All right, thanks a lot. Appreciate it, Bill. I guess we could open the floor now to any questions from any commissioners they have for Bill, or any discussion.
I've got a few, Mr. Chair.
All right, Commissioner Lau, floor is yours.
Thank you. First off, Mr. Stafford, thank you for being here. Appreciate that. And General Counsel, thanks for the materials that you put together. What I noticed is missing from the materials is one of the later filings. It looks like it was a motion to strike filed by the plaintiffs after right. Was there a particular reason that was left out?
No, I'm happy to provide that, and I'm happy to discuss that.
Okay. That's okay. So, you had also, I think, indicated that there may be some things you're uncomfortable in speaking about in this public meeting. but isn't it true that the only way that we can go into a shade meeting is if you decide so?
That's generally the case.
Well, what's the exception?
Say again?
What's the exception? You said generally that's the case. What's the
Yes.
exception?
If the commission were to direct me as counsel to pursue settlement options, I would do that. I would do as the commission directs, and I would, whatever information I would gather, that would have to be conveyed in a shade meeting. So what I would do is I would request a meeting of the commission, a public meeting that would go into a shade meeting to discuss the settlement options.
So it's not generally the case, it's always the case that you're the one that has to call the shade meeting, right?
Yes, but
so and speaking of, I'm sorry, go ahead.
No, I would take, if the commission directed me to pursue settlement options, I would take that as essentially as an order from the commission to gather that information and then call for a shade meeting. I would not consider that optional.
Okay, thanks for that clarification. So if the commission loses this case, it seems to me like that's a pretty big deal. And in fact, reading from one of the filings that you prepared, a final judgment in favor of plaintiffs based on a finding that requiring these disclosures is per se compelled speech would put at risk the entire financial disclosure scheme. Is that an accurate statement?
Yes, sir.
So when there's something that's a big, and we're losing now, right? We've lost a on the preliminary injunction. And it would seem to me like if that's the case, you would be encouraging your clients to do what the court said at the hearing, as far as I can tell, the only hearing we had, in which she says, I'm going to say you guys should talk to see, and then she goes on to talk about the most narrow form. So I'd really like to engage in a dialogue about why we're not being encouraged to have some kind of settlement discussions.
Well, I can give you, I guess the primary answer is this case is at its core a constitutional challenge to a statute or an amendment to a statute lawfully passed by the legislature. And our office does not, would not be in a position to concede that a statute lawfully passed by the legislature is unconstitutional. So we feel that in this case, as in any constitutional case, our duty here is to defend the constitutionality of the statute. Given that it severely limits our settlement opportunities. That being said, that does not, nothing that is happening in this, the status of the litigation should in no way, affect the commission's opportunities or options to revisit its recommendation as to the Form 6 requirement for municipal elected officials. That in addition, there's a question about what, in terms of settlement, what the commission would be able to do in terms of a settlement that would, could potentially be acceptable to the plaintiff. With respect to legislation, the commission is, limited to making recommendations to the legislature. And it would be up to the legislature whether or not to act on any recommendation of the commission. So Again, I'm happy to explore that, but in terms of whether this would be a case that lends itself to settlement, I would have to say no. It's not like a your run of the mill damages case or personal injury case that just a matter of plaintiff asking for this number of dollars and the defendant saying no, we're not going to do it, and that would lend itself to a number as a settlement. That is not, in my opinion, that is not the case here.
And understood, right? And yet there does seem to be some variability in potential outcomes in terms of what is on whatever form is required. And you'll recall the judge at the hearing referred to Form 3, sort of picking a number between 1 and 6. Maybe, and the implication was maybe there's a solution that doesn't require the net worth down to the penny, which I understand is the commission's position today. Even though our executive director, I think during her deposition, testified that that really isn't going to be helpful to protecting the public trust, having it down to the penny. And so it seems to me like, and I understand, and our general counsel told us at our most recent meeting that any settlement would be difficult. I think that was the word that was used. And I understand that, but I would like to see some overture toward trying to see if there's a resolution that would have disclosure requirements that would be at a level that the plaintiffs would agree to, and would have to be conditioned, of course, on, and maybe there's, I'm not a litigator, counselor, so you all can come up with the ideas and the ways to deal with this, but maybe there's a stay that I would guess the judge would be very happy to approve, and then go to the legislative leadership and try and work out a legislative solution that could be passed. And I understand there's a governor involved also. We'd have to get the solution ultimately would have to do that, include that. But it would seem like fine tuning the disclosure requirements is something that does have a more similar to the splitting the dollar amount in a negligence claim than only one choice of either yes or no. And so maybe you could respond to the concept of reduced disclosure that would comport with what the executive director, not just in the heat of testimony as she was subjected to not long ago, but in a chance to meet with staff and hear from the commission to see what really is helpful to this mission that we have, the very appropriate mission. And so I've got one question on the table. Let me throw another one out there also, and you can have a double hit on this then. You mentioned the 1976 Sunshine Amendment and that the Form 6 requirements are there. Would you also be able to respond to whether the legislature has the Florida constitutional authority to modify those changes from what the Sunshine Amendment says? And I won't add on a third question right now. I'll stop there.
All right.
Thank you.
Certainly. And I would say with respect to the Form 3 option that the judge mentioned, I'm not in the policy making business. That would be for the commission. But certainly if the commission directs me to, I can pursue that. And I believe Jamie Cole, plaintiff's counsel, is in the gallery, so he will have heard what the commission or what the commission may potentially be interested in, and that can be pursued. One of the concerns would be if, I would say, but again, I may be speaking out of turn, but if there would be a Form 3 requirement, I'm trying to think that through, but it's certainly a possibility, and in terms of whether or not the judge would stay the case, I would not be as sure as you, Commissioner Lyle, because of simply where the status of the case is. There is nothing there, like, there's no discovery to be happening. It's not a case that's gonna, linger on and involve a lot of cost from this point forward. If there is, if the commission directs me to, and I speak with Mr. Cole about this, and I get any information, I will certainly pass it on. And again, there is not this litigation. The only thing that the commission is not permitted to do during the pendency of this case is enforce the Form 6 requirements against city elected officials and candidates for office. There is nothing that would prevent the commission on its own from pursuing these options. So I wanted to make it clear in case that there was any impression that the commission was not, did not have any power to move forward on this issue without any direction from the court. And I'm sorry, the second.
No problem. You did a very thorough job with the first answer. So let me restate the second question. You had referred earlier in your remarks to the Sunshine Amendment and the constitutional, and you made a reference to the Form 6 requirements in the Constitution. And what I'm trying to be sure that I understand correctly, let me just tell you what I think that what I understand is that the legislature can modify those requirements. And modify would include downgrading those requirements in terms of who they would apply to and what would have to be on Form 6. It's back to whether a Form 3 could be something that would be consistent with the Florida Constitutional Sunshine Amendment.
I believe I have not looked into that particular issue in depth, but it's my understanding that that is the consensus about the amendment. Before I would like to look at that in any more detail in order to give a more definitive answer. But certainly, like with the Form 1 requirement, that is not set forth in the Sunshine Amendment. That was something the legislature did on its own. So that is purely a creature of statute. So if there were any discussions about a Form 3, I would expect that the legislature would have that same ability with respect to municipal elected officials.
And if some movement comes to fruition in terms of developing this Form 3, I guess one of the things that the legislature could do would be to have some studies, to have some of that evidence that at least the plaintiffs say is a prerequisite for being able to pass this kind of law. So they would essentially get not necessarily a redo, but a chance to ward off similar challenges later, because I understand the plaintiffs don't speak for everybody who could be impacted. Right. Mr. Chair, I think that concludes my questions right now. Thank you.
Thank you very much, Commissioner Lyle. I just want to welcome Commissioner Bush. Thank you for joining us. I'd like to ask a question, real quick, something you touched upon. There's a presumption, obviously, that the legislature passes laws that are constitutional. I know that's a foregone conclusion. But just to make sure that it was this commission that actually asked for these amendments to take place, correct?
That's correct. In my understanding of what happened at the legislature was that this happened in that the legislatures that this came about in the legislature completely independent of the commission's recommendation. I believe that one of the I guess, key legislators received a call from a constituent that brought this discrepancy to that legislator's attention, and that's what led to the amendment. I'm sure the commission weighed in on that, with the pending legislation.
Right, so it turns out that we were making these requests. Obviously, one of the either senator or representative heard something from one of their constituents, and I guess that led to the movement finally of this. And the other thing you mentioned, and I think Commissioner Lau mentioned this, was that if this were to go down, I think you mentioned, or Commissioner Lau quoted you saying, as I wrote it down, the financial disclosure scheme would be in trouble or in jeopardy, correct?
That's that's the danger, that it could be interpreted in that way.
Right, and really, we're there now. I mean, at the end of the day, we're being challenged on a constitutional challenge based on a statute we passed. They believe, the plaintiffs, not all of them, but the ones obviously moving forward, that it's too much disclosure, it's compelled. But I feel there's already a target on the financial scheme to begin with, and I think that other than seeing it through, would still leave challenges coming in the future. Nothing stops other people from challenging it based on the same legal basis, correct? Notwithstanding a Form 3 or even a Form 1. For all we know, the Form 1 can be up for grabs as well. Is that correct?
That was, one of the arguments that we made is a determination that financial disclosure equals compelled speech I would consider that a dangerous precedent that would put, for example, the rest of the requirements set forth in the amendment for state and county officials to make the same claim. And that's one of the things that that we're concerned about, is just the general precedent that a disclosures required of government officials is equal to compelled speech, having to have something on a member of the public to have something on their license plate that they don't necessarily agree with. Obviously there are differences, there are different interests involved that would certainly cause our office concern if there was that judicial ruling and that was not preserved, that was not ruled on appeal.
Right. Yeah, just like the fact that I think everybody, I guess, in New Hampshire has to have a plate, whereas here you don't have to run for office, right? I mean, that would be a stark difference right there.
Correct. And there are other arguments that apply different standards to
correct
government employees and government officials.
Now, the last thing, just from a procedural standpoint, if the commission is interested in you reaching out to this, I like that term, by the way, Commissioner, I love it, like a reduced disclosure, or then maybe that was from the judge. But if that were to happen, we'd have to, through a motion, Steve, I'll defer to you as well, get a motion going to see if we want that to happen, and then Bill would turn around and then request a shade meeting based on our motion, correct? Would that be procedure, how it would go?
That's correct, Mr. Chair. A motion here and a vote by the majority to direct him to do that would be appropriate.
And then he would investigate.
Can I just ask when he comes? Yeah, can I ask for a clarification?
Ahead,
because I thought our counsel said that if that motion were to be made and passed, he would then go to the other side and we wouldn't have the shade meeting until that had happened.
That's my understanding of what I think.
Okay.
I think all three of us are talking about exactly that scenario.
Right, it has to go from here, the motion, to Bill. Bill goes, speaks to the other side, and then when he comes back to us, like normally, like an attorney does, hey, here's what I got, that would trigger the shade meeting, correct? Got it. I see the nodding heads. Okay, all right.
Yes.
All right. I don't have anything further. Does any other commissioner have any questions for?
Commissioner Lucas has her
I do,
hand
Chair.
up.
Hi.
Oh, go ahead.
Mr. Stafford, thank you very, very much for being here. I represent almost exclusively public entity clients, and the idea of giving my clients advice at a public meeting sounds abhorrent, and I don't envy the position that you're in. So thank you for trying to thread that needle as best you could. Steve could tell you all of my deepest feelings about the fact that we aren't allowed to talk to our counsel. But that's not for today, especially with this big of an audience. I wanted to also let you know that I can speak personally. I very much appreciate your observation that settlement in these types of cases is impossible. These are the kind of cases that I work on every day, and they don't settle because people don't want to concede that their statutes are unconstitutional, or that the statutes that they're charged with enforcing are unconstitutional. The Attorney General's office certainly is in the position of not defending the constitutionality of state statutes, and I think as an arm of the state, the commission needs to think seriously about backing off of its obligation to defend the constitutionality of a statute. And that's not reflective of, my personal views on the substance of anything we're talking about, but just simply as a body that's an arm of the state, we've got an obligation that I think we have to discharge. We're also not only allowed, but we're required to provide legislative recommendations every year. And of course, we've got broad rulemaking authority under Chapter 120. So there's nothing about this litigation that requires us to couple legislative recommendations, requests for, advice on rulemaking from our own staff. So I guess that's the only pushback I would have before we, if there's going to be a motion to discharge Mr. Stafford to go approach the plaintiffs who are hearing everything we're saying right now, I would just maybe push back and challenge the idea that any of the efforts that have been raised are things that need to be coupled with litigation in line of, the other, especially given the stages of litigation. But thank you again, Mr. Stafford, for being here, and I appreciate it. And thank you, everybody, for indulging me.
You're most welcome. And in Commissioner Lyle's defense, I did not take what he was discussing as a settlement involving a concession that the statute is unconstitutional. But
no, that's not what I was
Has-
implying. I apologize.
Right.
That's how it came across. Full-throated defense is all I meant. To the end. That's not what I meant to imply. I apologize, but that's how it came across.
Oh, no, but there would be no, the Attorney General's office would not sign. I can't imagine signing off on any settlement that would include any indication that the statute is unconstitutional.
Thank you, Commissioner Lucas. Any other questions? Anybody have any other comments? Meg?
Well, I'd venture a motion if you are ready for that, Mr. Chair.
I'll make sure I read it down clearly this time. Go ahead.
I'm sure our audio recording will pick it up. So I would move that the commission direct our counsel to approach plaintiff's counsel about a negotiated resolution that would bring this lawsuit to a conclusion and eliminating the future risk that a final judgment in favor of the plaintiffs based on the disclosures being a compelled speech would put at risk the entire financial disclosure scheme.
Somebody need to read that back, or can I get a second on that? Going twice? Going 3 times? I think Commissioner Bush is trying to get our attention.
Commissioner Bush, if you can unmute there.
I'll second that.
Okay, I have a first and I have a second. All right, let's take a vote. All those in favor say aye.
Aye.
And for the record, I see Commissioner Lyle, Commissioner Bush. Any opposition? Speak now. Any nays?
Nay.
Nay.
That was Commissioner Figures and Commissioner Lucas. I'm a nay on this. Commissioner Fuste
I'm a
Commissioner
nay as
Stewart?
well. This is Commissioner Bain.
Oh, Commissioner Bain, I'm sorry, I didn't see you down there. I apologize.
Nay.
Thank you.
Rich, nay.
And
Nay.
Commissioner Stewart?
Nay.
Okay. And I think that's it, right? My screen is not showing me everybody, but I think that's all the commissioners. Is that true, Carrie?
I believe so. If you'd like a roll call, the commission secretary is on here and she can call.
Yeah,
them.
let's do it just to keep it. Get a roll call going.
Commissioner Bain,
Nay.
Commissioner Bush,
Yes. Yay.
Commissioner Deskovich,
Nay.
Commissioner Figurs,
Nay.
Commissioner Fuste,
Nay.
Commissioner Lyle,
Yay.
Commissioner Lucas,
Nay.
Commissioner Stewart.
Nay.
Motion fails.
Okay. Thank you very much. Anybody have any more questions? And just one thing I wanted to do, because Commissioner Lucas is so good at it, I want to thank also Mr. Stafford for being here and being in this, yes, difficult position. Very difficult, but I appreciate it. Anybody have any other questions? All right, can I get a motion to adjourn?
Coupled with a happy Thanksgiving to all. Motion to adjourn.
Thank you. In a second, Commissioner
On
Stewart.
both counts,
Thank you very
second.
much. Yes, happy Thanksgiving to everybody. Thank you very much. And
Happy
enjoy the rest of the
Thanksgiving.
week. Thank you.
Thank you all. Travel safe.
God bless.
All right.
Bye.